19, was charged with sexual abuse of a child, continuous, victim under 14 years of age. All right, Mr. Chamness is present for the state. Mr. Davidson for the defendant. What are the announcements on these, Mr. Chamness?
This is going to be a plea on both cases. The continuous case, that is the one that ends in -20, not the one that ends in -19. The defendant is going to enter a plea to a lesser of aggravated sexual assault of a child. I had filed a Brooks notice in that cause number. My understanding is he's going to plead true to that cause number, thus making that case a mandatory life case pursuant to Penal Code 1242D. And then he's going to plead guilty and take a 50-year sentence on the child porn, which is to be ran concurrent with the mandatory life sentence. The 0824, not 0824, but the continuous case from 2019 is the same allegations found in the other one. That's just an indictment that had to be corrected. And so once this plea is finalized, that case will be outright dismissed.
All right, then, Mr. Rose, raise your right hand. I need to get you sworn in. Do you solemnly swear or affirm that the testimony you will give in the two cases now on trial will be the truth, the whole truth, and nothing but the truth, and that all the plea documents in each case that show you signed the document, you are now swearing to the documents that indicate they're sworn to, and you're swearing to each one of these documents freely, intelligently, knowingly, and voluntarily. Is that all correct?
Yes, sir.
All right, if I follow in Mr. Chamness, I suppose just right off the bat, which plea, Mr. Chamness, do you and Mr. Davidson want to do first? Do you want to do this by the numbers 2410585-20 on the sexual abuse of a child, continuous, victim under 14? Looks like by the numbers on the indictment, that would be the first case. So do you want to do it first?
Let's do that one first, and then we'll have to, I'll go ahead and urge my Brooks notice on that case as well, which will require the defendant to not only plead guilty to the amended indictment, but also have him plead true to the Brooks notice, which is what makes it mandatory life.
All right, well, I'm looking in the file here just to be sure I'm following you since I'm looking at it for the first time. 2410585-20, that indictment charges sexual abuse of a child, continuous, victim under 14. That is the plea that we are going to do first. Is that correct, Mr. Chamness and Mr. Davidson?
That's correct.
Yeah, Judge, that's correct, but what the stipulation of evidence in the plea papers that you have reflects what Mr. Chamness said about what the status of the charge is, the lesser included. I don't know if your indictment reflects that you're looking at. Yeah, but I know the stipulation does.
Well, hold on a minute then, because the indictment on the charge of sexual abuse of a child, continuous, victim under 14, that's a straight up indictment for that offense.
And Your Honor, if it's okay, then I'm going to make a motion to amend the indictment. We had already changed.
Hang on a second, Mr. Chairman.
Okay.
Y'all, I'm just getting a chance now to look at this. In cause number 2410585-20, State versus Bradley Rhodes, there is a state's notice of intent to seek a higher punishment based on a prior conviction pursuant to Brooks versus State, 957 2nd 30, Texas Court of Criminal Appeals, 1997. That is the order which the court has already signed. And I'm showing on the face of that charge of sexual abuse of a child, continuous victim under 14. That would be a first-degree felony. So I'm just trying to follow, where does that order granting the Brooks notice of intent to seek a higher punishment based on prior convictions pursuant to Brooks versus State? Where does that come in on it?
Okay, Your Honor. So the defendant has a prior conviction for aggravated sexual assault of a child. If he pleads to any offense greater than an indecency by contact, sex assault, continuous, or anything, that makes him a twice convicted sex offender, which results in a mandatory life sentence. The indictment in 0585-20, we are pleading him to one of the lesser included offenses in 0585-20, which would be an aggravated sexual assault of a child. The Brooks was filed because it's necessary for him to also plead true to the prior sex assault charge, thus making the punishment range nothing but mandatory life.
All right, let me see if I can get with you on that, Mr. Chamness. The file in 2410585-20. I understand what you're saying, but I have an order granting the state's notice of intent to seek higher punishment based on prior convictions pursuant to Brooks versus the state. Granting your motion, state's motion of intent to seek a higher punishment based on Brooks versus the state.
I believe that Mr. Chambliss was about to make a motion to amend, which we do not oppose.
All right, just a minute, I would think that I guess maybe that's where I'm not sure, because there's no, on this 2410585-20, the only thing I have in the file, not the only thing in the file, but I have the order granting the state's notice of intent to seek a higher punishment versus Brooks on Brooks versus state. Then I have the indictment itself, sexual abuse of a child, continuous victim under 14. I don't see anything further in the file. So am I missing something?
Your Honor, I need to just orally amend the indictment on the continuous to strike the language that makes it a continuous and would thus make it an sex assault of a child.
Do you have a motion you can file that does that?
Well, Mr. Davidson is waiving it, and my understanding is that I can orally amend and interlineate the indictment.
Well, then, since we're going to do it that way, why don't you take your time and not go too fast? Because I'm going to have to write on the copy, which then I'll have to transfer over to the original. So what is your amendment you're making with no objection, as I understand it from Mr. Davidson, to the indictment charging sexual abuse of a child victim under 14? Just your amendment to that indictment, what is it going to be? And go slow, because I'm going to write on the copy, then transfer it on to the original.
And Judge, if you look at the plea papers, the stipulation of evidence on the plea papers that you have in front of you, I believe you have, it is exactly what Mr. Chambliss is about to tell you. So he can hear it orally and also see it in writing too.
Okay, I've got a set of plea papers in one case. 2410824-19. It's the only one of the three files that has plea papers. So I said, here you go, here's the other two. There's the other two. I don't see any plea papers in them. I have this file that has the plea papers. Unless I've just missed them. Okay, here you go, let me do that one. I have to get a younger fella to do this pretty soon. I think he's coming. So basically then, now that Denise, as usual, has gotten me off my arrows to the straight and narrow, she has gone through the file. There's three of them. She's gone to the proper file with court. Of course, I'm just looking at it for the first time. Now she's handed me 2410585-20, State versus Bradley Stephen Rhodes, on an indictment charging the offense of aggravated sexual assault of a child. Victim, continuous victim under 14. That's 2410585-20. That is the indictment. Now I'm going over to the stipulation of evidence. Now run that by me again, Mr. Chairman. That's how we're doing that again. I don't see a motion to amend it with an order. So apparently I'm going to change. How are we going to do this?
We're just going to strike, Judge, we're just going to strike some of the language in the indictment to where that the indictment tracks an aggravated sexual assault of a child indictment,
Okay. I'm with you. That's what I thought we were going to do. And then Mr. Davidson started talking about the stipulation of evidence. Well, the stipulation of evidence is obviously a stipulation of evidence signed and sworn to the defendant, which reflects what you're now going to dictate to me to change in the indictment. I think what Mr. Davidson somehow was suggesting was that I take the stipulation of evidence in 0585 and then somehow transfer that over and make those changes in the indictment.
And Your Honor, I'm sorry that I've made it confusing, but I had the ability to make the stipulation track what we wanted it to do, but I couldn't obviously change the court's indictment until we had the hearing.
Okay, I'm getting ready to change the court's indictment. Where the indictment for sexual abuse of a child, continuous victim under 14, in 2410585-20, I've got the stipulation of evidence. Where does the change start, Mr. Chamness?
So right after the defendant's name, where it says did then and there, midway through the indictment, after the comma, we're going to strike the language during a period that was 30 or more days in duration, namely from, that's going to be struck.
Here's what we're going to do, which is the way this should have been done. I'm going to recess this hearing. I'm going to send these plea papers back to Mr. Chamness, who will meet with Mr. Davidson, so that y'all can get the changes in the, I know you can't change the indictment, but otherwise I'm going to have to try to take the stipulation of evidence and make the changes in the indictment. And I've got a stipulation of evidence over here. I mean, this is the first time I'm seeing it and didn't know any of this was going to take place. So this is the first time I'm seeing it, and I've got a stipulation of evidence in 2410585-20. Now that stipulation of evidence that I've got, now I'm going to, and I want to be sure I get the changes correct before I start marking on the grand jury indictment, or Mr. Chamness will be going back to grand jury. So I need to be sure, let me finish. I need to be sure I get this right, looking at the indictment that needs to be changed, where it will match the stipulation of evidence. All right, I'm looking at the copy of the indictment. Now take your time, Mr. Chairman, because I haven't seen it like y'all. Where are you starting?
Judge, if you want, and I know Mr. Davidson has seen it because it was done in my office, I can send Mr. Gilmore down to the court with my copy of the indictment that is already marked up, if that would help.
Let's do this. Actually, fortunately, I have an assistant criminal district attorney sitting in the courtroom with a mask on. I'm going to hand all of these files to him with all your copies, and he can take it back up, get with you, and get it done, making the stipulation, the changes on the stipulation, and then I'll write those changes, interleading them into the original, because if I fail up the original, it's going back to grand jury. No other way to do it. Mr. Gilmore's coming upstairs, Mr. Chambers, to meet with you.
Okay.
And just the defendant needs to stay where he is. Mr. Davidson, I guess, is at his office. He can stay where he is. We'll go back on the record after all that's done. Mr. Gilmore's on his way back up, Mr. Chambers, and get all it done. No, you cannot interlate. I'll have to interlate the original of the indictment, but I want to be able to look at the stipulation of evidence, the copy you've marked and written in on so I can match it up with the original so I don't foul it up. That's the bottom line. We're in recess till that's all done, until Mr. Gilmore gets back.
Yes, sir.
No, ma'am. He said that we're in recess until the DA can get some paperwork done real quick.
They're open 24/7. That's child abandonment, child abandonment. That's what she did. You need to talk to your attorney, don't be talking to anybody else about the case, because I don't want to be involved in this stuff, to be honest. If you're talking to us about this case, I don't want to know about it. So they're doing paperwork on your case?
Mm-hmm.
Okay. Hold them both in front of you. Don't take it down. Put the one in front of you like that. There you go. And hold both of them full up. Here's the camera. There you go. two different links to. Will be turned on Monday right now.
Lou, is there one of these competency exams by Dr. Proctor in this file?
Well, he just sent one for both files, but we've already put all that on the
We
record.
put all that on the record.
Mhm.
All right, we're going back on the record in calls number 2410585-20, State versus Bradley. Stephen Rhodes, present before the court with his attorney, Mr. Davidson. Mr. Chairman is present by Zoom representing the state. All right, Mr. Rhodes, going up on the screen, in fact, up on the screen now, this is why the court had to stop. Up on the screen now is the indictment in cause number 241-0585-20. State versus Bradley Rhodes, which shows a charge of sexual abuse of a child continuous victim under 14. Now the state, Mr. Chamness, has made a motion to change this indictment with no objection from Mr. Davidson, as I understand it. The changes to the indictment have now been made on the indictment by the court. For the record, Mr. Chamness, go ahead and put on the record your motion to amend this indictment.
Your Honor, at this time, the state would move to amend the indictment to track the stipulation of evidence which is found within the plea papers, which would change this initial charge of continuous sexual abuse of a child under the age of 14 to a single count of aggravated sexual assault of a child. We would also, at that point, urge our Brooks notice, which I believe the court has already granted, which would then put us in a situation where when the defendant pleads guilty to the aggravated sexual assault and pleads true to the Brooks notice, it would make the punishment range mandatory life.
Is that correct, Mr. Davis?
It is, Your Honor.
Mr. Rhodes, you've been sworn in. Do you understand all Mr. Chambliss just said, which your attorney says is correct?
Yes, sir.
All right. The interlineations to the indictment have now been made by the court directly off the stipulation of evidence in this cause number 24105-85-20. So the court is granting the state's motion to interlineate the indictment. And those changes are reflected on the original, not on the stipulation of evidence that's actually up there. The stipulation of evidence that I have in 24105-85-20, take it that that stipulation of evidence is going to be amended, or has this stipulation of evidence, does this stipulation of evidence stage 2 reflect the changes made in the indictment, Mr. Chambliss?
It does, Your Honor.
The state's motion to amend the indictment in cause number 241-0585-20 is granted. The interlineations have been made by the court. The motion to interlineate the indictment is granted. The indictment, those changes are reflected on the indictment. Those changes were made by the court. The interlineations through the original of the indictment, for the record, were done by the court. The indictment reads now in cause number 24105-85-20. In the portion of the indictment where the court has made the changes, it reads, on or about the first day of March 2011 and anterior to the presentment of this indictment in the county of Smith and state of Texas, Bradley Rhodes did then and there, namely from on or about first day of March 2011, when the defendant was 17 years of age or older, commit sexual abuse against AH, a child younger than 14 years of age, namely, then and there intentionally and knowingly caused the penetration of the sexual organ of AH, a child who was then and there younger than 14 years of age, by defendant's finger against the peace and dignity of the estate, signed by the foreperson of the grand jury. So the state's motion to interlineate the indictment in that manner has been done. The motion's granted. Those interlineations have been made by the court. Are those interlineations correct, Mr. Chamness?
They are correct, Your Honor.
Are those interlineations correct, Mr. Davidson, so that the indictment now reflects the motion of the state to interlineate the indictment?
That's correct, Your Honor.
All right, Mr. Rhodes, do you understand those interlineations and changes that have been made in the indictment?
Yes, sir.
All right, the stipulation of evidence, I'm going to go back through. I'm probably going to have to do these one at a time. It'll be a while. But the plea papers, I'll go back and take them by the numbers. In cause number 241-0585-20, these plea papers have now been prepared for the record. It appears to the court after the changes that have been interlineated into the indictment, because 241-0585-20, now that indictment and that cause number now charges aggravated sexual assault of a child. Is that correct?
That's correct, Your Honor.
All right, now I'm going to go to the indictment up at the top where it says charged to try to eliminate any confusion. And I'm going to interlineate. This is above where it says in the name and by the authority of the state of Texas. It currently says charged sexual abuse of a child, continuous victim under 14. The court's now going to interlineate out that language, and the court is going to write in where it says charged aggravated sexual assault of a child. Is that correct?
That's correct, Your Honor.
Is correct, Mr. Davidson?
It is, Your Honor.
And I understand it's the body of the indictment, those interlineations that count, but I don't want somewhere down the road there to be any confusion about what the intent of the state and defense and where in court was in this case. So the court is interlineating out where it says charged sexual abuse of a child, continuous victim under 14. That is being interlineated out. Again, it's not the caption that counts. And now the court will write in where it says charge aggravated sexual assault of a child. All right, now that charge portion of the indictment, I'm talking about above where it says in the name and by the authority of the state of Texas. That charge now reflects what is actually charged in the indictment itself, aggravated sexual assault of a child. And we'll move to the plea documents in this case. Mr. Rhodes, you've been sworn in. Do you understand all the changes the court has made and the effect of those changes in this case where you're now charged with aggravated sexual assault of a child?
Yes, sir.
All right, now we're going to go through the plea documents in this case, starting with the plea agreement, Mr. Rhodes. Have you gone over all these plea documents with your attorney, Mr. Don Davidson, where he's explained each one of these plea documents to you? And have you done that first of all?
Yes, sir.
There's a signature on the first one there down under where it says agreed punishment recommendation. It's signed Bradley Rhodes on the line above where it says defendant. Is that your signature?
Yes, sir.
It's also signed by Mr. Davidson, your attorney, and Mr. Cham, the state's attorney. This is your plea agreement in this cause number where and you can see that the plea documents have been done, they've been changed, so that you see the plea documents reflect the charge as aggravated sexual assault of a child, which is now the offense actually alleged in this indictment, in this case, 2410585-20. You have a plea agreement with the state. Your plea agreement with the state tells the court that if you do enter a plea of guilty to this offense of aggravated sexual assault of a child, first degree felony as alleged in this indictment, Mr. Chamness, the state's prosecutor, is recommending a sentence of life in the Texas Department of Corrections Institutional Division. As part of your plea agreement, a life sentence assessed by the court following the plea agreement in this case, the life sentence in TDC, will be ordered to run concurrent with the sentence assessed in cause number 2410824-19. Is that your plea agreement?
Yes, sir.
In addition, you'll see on the X where it says motion to dismiss. Mr. Chamness will dismiss indictment number 241-1894-19. So basically your plea agreement is if you plead guilty to this offense in this cause number 2410585-20, charging aggravated sexual assault of a child, first degree felony, Mr. Chamness is going to recommend your sentence at life in the Texas Department of Corrections Institutional Division. Obviously, the court will follow the recommendation, then the court will order the life sentence in this case to run concurrent with the sentence you receive in cause number 24108-24-19, and then the state will dismiss 241-1894-19. That is your plea agreement, is that correct?
Yes, sir.
Is that it, Mr. Davidson?
Yes, Your Honor.
Is that your recommendation, Mr. Chamness?
It is, Your Honor.
Then we have the other plea documents that you've signed or signed and sworn to, signed by your attorney, Mr. Davidson. There's an acknowledgement of admonishments. It gives you the full range of sentencing. Number one, under the acknowledgement of admonishments, you will see where it says the offense for which you are charged is aggravated sexual assault. And the range of punishment for such offense is mandatory life under section 12.42C2 of the Texas Penal Code. Do you understand that?
Yes, sir.
The other admonishments, 2, 3, 4, and 5, which is on the second page, have you gone over those admonishments with Mr. Davidson where you understand all those admonishments?
Yes, sir.
The next document that you signed or signed and sworn to, Mr. Rhodes, in this cause number is a waiver of trial by jury. Do you understand that waiver of trial by jury signed by you is telling the court you wish to give up your right to a trial by jury and proceed on your plea of guilty to the indictment without a jury. Is that correct?
Yes, sir.
There's a signed and sworn to waiver of confrontation with witnesses. You've signed the document. I've now sworn you to it. So do you understand that?
Yes, sir.
There's a stipulation of evidence. The stipulation of evidence in this cause number 2410585-20. Do you understand that is a written judicial confession by you to the offense of aggravated sexual assault of a child as alleged in cause number 2410585-20. Do you understand that?
Yes, sir.
Did you sign and swear to this stipulation of evidence states two of your own free will and sign and swear to it voluntarily?
Yes, sir.
The next document is an agreement to stipulate testimony. And the next document is a form for a waiver of appeal and waiver of motion for new trial, request to waive the pre-sentence, which is approved by the court. Then the trial court certification of your rights to appeal, which will be signed by the court, already signed by you and Mr. Davidson. In the applicable sections, it is checked X, is a plea bargain case and the defendant has no right of appeal. And in its check X, the defendant has waived the right of appeal. Is that all correct?
Yes, sir.
All right, the next document that I have in this case is the certification of advice you've received from Mr. Davidson in this case, and then the discovery compliance forms. You do understand all these plea documents, is that correct?
Yes, sir.
And it is your decision to go forward on your plea of guilty to the indictment in this case as amended, which now charges aggravated sexual assault of a child without a jury. Is that correct?
Yes, sir.
All right, I'm going to go through and ask you some questions now. Do you read, write, and understand English?
Yes, sir.
Or have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
Yes, sir.
When was that?
The last time was 2013.
All right, let me take a judicial notice of a report that I have from Dr. Proctor. This was over in cause number 241082419. I have a report from Dr. Proctor. I probably took judicial notice of it at some earlier point, but the court had ordered that you be examined by Dr. Proctor. The court takes judicial notice of Dr. Proctor's extensive qualifications and experience. He has conducted many examinations of defendants on the issue of competency in this courtroom. I have in front of me as part of the file a report of competency to stand trial evaluation. Defendant Bradley Rhodes, citing two cause numbers 2410824 and 2411894-19, listing the charges, the court and the judge. It's an extensive detailed report as usual by Dr. Proctor, who's board certified forensic clinical psychologist, neuropsychology, extremely well qualified to perform many of these competency examinations by the court. The report itself is a total of 5 pages, 6 pages, 7 pages. And when we get to the bottom of the 7th page, as usual, Dr. Proctor sets out his opinions. Based on the findings of this evaluation, my training and experience, and a reasonable degree of psychological certainty, the following opinions are offered. 1, the defendant has sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding. The defendant has a rational as well as factual understanding of the proceedings against him. 3, based on the above, it is the opinion of this evaluator that the defendant presently is competent to stand trial. The date of that report, as I've said, it was evaluation date was 5/15/20. This report is dated June the 24th, 2020. Court receives, accepts the report, accepts the findings of the report. You have reviewed the report, correct, Mr. Davidson? Mr. Davidson, have you reviewed the report?
I think he froze, hang on.
Yes, Your Honor, I have.
All right, I've gotten down, I've asked the defendant, Mr. Rhodes, has he ever been confined in a mental institution or under psychiatric treatment? He said, yes. I've now read excerpts from Dr. Proctor's report, as well as his opinion, reached his conclusion that the defendant is competent to stand trial. The court receives and accepts and approves Dr. Proctor's report. Do you understand everything you are doing in court today, Mr. Rhodes?
Yes, sir.
Have you gone over everything about the facts of your case with your attorney, Mr. Davidson, and everything you're doing in court today with your attorney, Mr. Davidson?
Yes, sir.
Is he competent, Mr. Davidson?
Yes, Your Honor.
Any evidence of incompetence, Mr. Chamness?
No, Your Honor.
Court notes State's counsel signed his consent to approve the waiver of trial by jury. The court approves the waiver of trial by jury. All the other waivers in the case signed by the defendant, signed by his attorney. All right, you understand, Mr. Rhodes, all of the allegations and the charge in the indictment as it now stands for aggravated sexual assault of a child, first-degree felony, is that correct?
Yes, sir.
You understand all these plea documents that I've gone through, identified that you've signed or signed and sworn to, is that correct?
Yes, sir.
You've gone over the indictment and all your plea papers with Mr. Davidson, is that correct?
Yes, sir.
Do you understand the allegations in the indictment, the full range of sentencing, and all your plea papers that you've signed or signed and sworn to?
Yes, sir.
Do you have any questions for me about anything in this cause number 241-0585-20, where the indictment now charges you with aggravated sexual assault of a child as alleged in the indictment?
No, sir.
All right, in cause number 241-0585-20, what is your plea today to the indictment charging you with the offense of aggravated sexual assault of a child, first-degree felony, as alleged in the indictment?
Guilty.
Are you entering your plea of guilty to the indictment today freely, intelligently, knowingly, and voluntarily?
Yes, sir.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Has anyone threatened you in any way or promised you anything or coerced you, made you enter your plea of guilty?
No, sir.
Are you entering your plea of guilty to the indictment today as a result of any type of delusion in your mind or any type unrealistic hope of pardon, parole, or leniency?
No, sir.
All right, the court does receive and accept your plea of guilty to the indictment charging you with aggravated sexual assault of a child, a state jail felony, as alleged in the indictment. I've got some plea documents that I need to be sure and go over with you. I believe I've gone over all the plea documents with you, Mr. Rhodes. You do understand all those plea documents. You signed them or signed and swore to them. You understand your plea agreement, where
Yep.
now that you've pled guilty, you understand that the state is recommending life in the Texas Department of Corrections Institutional Division. Under your plea agreement, it'll run concurrent with the sentence assessed in the other case. Then the state will dismiss 241-1894-19. Do you understand all that?
Yes, sir.
Is there any legal reason to bar a formal pronouncement of sentence, Mr. Davidson?
No,
Your Honor, I think for procedural purposes, I need to have the court actually read the Brooks notice and have the defendant plead true on the record to the prior sex assault.
that's correct, Your Honor.
Okay, Mr. Chambliss. See, Boo, you down there, where's the Brooks notice? Maybe I'm just not coming across it. All right, I now have the Brooks notice in cause number 241-0585-20, State of Texas versus Bradley Rhodes. State's notice of intent to seek higher punishment based on prior convictions pursuant to Brooks versus State to the Honorable Judge of said court. Comes now the State of Texas by and through her undersigned Assistant Criminal District Attorney provides written notice of its intent to enhance the punishment range for the present case, cause number 2410585-20, based on the following. Prior to the commission of the above style, hereinafter style, the primary offense, on September the 26th, 2000, in cause number A10065 in the 173rd District Court of Henderson County, Texas, the defendant was convicted of the felony offense of aggravated sexual assault of a child. Mr. Rose, is your plea to those allegations true or not true?
True.
Are you entering your plea of true to these allegations freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, do you understand by entering a plea of true to these allegations in the Brooks notice that it enhances or increases your range of sentencing in this case?
Yes, sir.
Let me go back to the plea documents now. When I went over the admonishments with you, I advised you that under the number one, the offense for which you're charged is aggravated sexual assault of a child. The range of punishment for that offense is mandatory life under section 12.42C2 of the Texas Penal Code. Do you understand that?
Yes, sir.
When you entered your plea of guilty to the offense alleged in this indictment, did you understand that when you did plead guilty to the offense alleged in this indictment, that the court would have a mandatory sentencing provision before the court? I mean, you certainly knew you were going to be sentenced to life, but did you understand that the court would be sentencing you to a mandatory life sentence under 12.42C2 of the Texas Penal Code?
Yes, sir.
And you have, this is one of the plea documents that you have signed and sworn to, is that correct?
Yes, sir.
Anything else on that, Mr. Chamness?
Your Honor, at this time, we would just offer states 1, the plea packet, states 2, the signed and sworn to stipulation of evidence, and states 3, the discovery compliance acknowledgement.
No objection.
All right, State's Exhibit 1, all the plea documents, which includes the acknowledgement of admonishments and all the other plea documents approved by the court and admitted into evidence as State's Exhibit 1. State's Exhibit 2 is the stipulation of evidence. Is that already in, Mr. Chamness?
It is, Your Honor.
It's in, correct, Mr. Davidson?
That's correct, Your Honor.
Or is there anything else, Mr. Chamness, you need to offer and get it admitted into the record?
Not for purposes of guilt innocence. I do have states 4 for punishment for sentencing purposes, which is a digital copy of the state's written discovery that we would offer.
Is there anything else in terms of the plea, the questions I have asked the defendant and his responses? Is there anything else that you need to be sure the court covers in the admonishments?
I don't believe so, Your Honor.
All right, the court then in this cause number 241-0585-20. The court in this cause number, based upon the defendant's plea of guilty to the offense alleged in the indictment now, and the evidence presented and admitted into the record by the court does find the defendant guilty of the offense alleged against him by the state in indictment cause number 2410585-20. Court finding the defendant guilty of the offense alleged against him by the state in its indictment based upon his plea of guilty and the evidence admitted into the record by the court finds the defendant guilty of the offense of aggravated sexual assault of a child. Court follows the plea agreement and the recommendation of the state and assesses the sentence in the case at life confinement in the Texas Department of Corrections Institutional Division. Sentence of life confinement in the Texas Department of Corrections Institutional Division will be ordered to run concurrent with the sentence assessed in cause number 2410824-19. Motion to dismiss will be filed in 2411894-20. Any legal reason to bar formal sentencing, Mr. Davis?
No, Your Honor.
All right, the court in the case then, based upon the defendant's plea of guilty to the offense of aggravated sexual assault of a child as alleged against him by the state in its indictment, and the evidence presented and admitted into the record by the court does find the defendant guilty of the offense of aggravated sexual assault of a child as alleged in the indictment. The court follows the plea agreement and the recommendation of the state, and the court assesses the sentence in the case at life confinement in the Texas Department of Corrections Institutional Division. No fine is assessed, court costs are ordered paid, restitutions are to be paid as determined to be due by post sentence. Any legal reason to bar formal sentencing, Mr. Davidson?
No, Your Honor.
Finding none, the court does formally pronounce the sentence. The court does find the defendant guilty of the offense alleged in the indictment, aggravated sexual assault of a child. Follows the plea agreement for recommendation of the state, assesses the sentence at a mandatory sentence under the statute at life confinement in the Texas Department of Corrections Institutional Division. No fines assessed, court costs are ordered paid. Restitutions ordered as determined to be due by post sentence. Motion to dismiss will be filed in 2411894-19. The life sentence assessed in this case will be ordered to run concurrent with the sentence assessed in cause number 2410824-19. Waiver of appeal in this case and waiver of motion for new trials received, accepted by the court. Sentence is formally pronounced at life confinement in the Texas Department of Corrections Institutional Division with credit for time served. You got another one on him, Doug?
I do.
Judge, he does waive his right to appeal.
Well, I said the waiver of appeal was received and accepted by the court. I suppose, Mr. Rhodes, just to be clear, you understand, as the document says, you have a right to appeal except for the fact this is a plea bargain case, and as your certification signed by you and Mr. Davidson says to the court, you are waiving and giving up your right to appeal. Is that correct?
Yes, sir.
Are you waiving and giving up your right to appeal freely, intelligently, knowingly, and voluntarily?
Yes, sir.
Mr. Don Davidson has been your court-appointed attorney in this case. Are you satisfied with Mr. Don Davidson's legal representation?
Yes, sir.
And Judge, while you're getting that other case for a plea, can I put one thing on the record?
What other case?
The second case, the child pornography case that he's about to plead to. Next.
You can put whatever else on the record you want to, Mr. Davidson.
Yeah, I just want to put on the record that part of the plea negotiation was in amending the indictment so it was aggravated sexual assault of a child from continuous sexual assault of a child under 14. That both of those, if Mr. Rhodes had gone to trial, would both have been mandatory life. But the mandatory life under the aggravated sexual assault has a period of 35 years, and then he's eligible at that point for parole. If he had gone to trial on the continuous, he would have not been eligible for parole at all. So if he had received the mandatory life sentence. So I just wanted to make sure the record was clear of why we amended it. It was part of the plea negotiations, and it's reflected in the plea papers and what Mr. Chambliss has previously said.
All right, the waiver of appeal is accepted. Waiver of right to file the motion for new trial is accepted. Court has already formally pronounced sentence finding the defendant guilty of the offense alleged In the indictment and assessing a sentence at mandatory life confinement, the Texas Department of Corrections Institutional Division in cause number 2410585-20 to run concurrent with the sentence in 2410824-19, waiver of appeals accepted. Is that going to be the only one on this defendant?
No, we have a child pornography case where the plea agreement is for 50 years.
I took it.
Let me
It's
get
this
all
one.
this to Denise, all this different papers we've got to get it in the file. All right, the next indictment's cause number 24108-24-19, State versus Bradley Rhodes. On the indictment charging the offense of possession with intent to promote child pornography. Defendants before the court by Zoom with his attorney, Mr. Davidson, by Zoom. Mr. Cham is present by Zoom. Do you want to waive the reading and presentation of this indictment in cause number 24102? Cause number 24108-24-19, all the other formalities, Mr. Davidson.
Yes, Your Honor. His name is set forth correctly. We've had sufficient time to go over it. We'll waive the reading of the indictment.
All right, Mr. Rose, raise your right hand like you did before. Do you solemnly swear or affirm the testimony you'll give before the court today will be the truth, the whole truth, and nothing but the truth, and all the documents signed and then sworn to by you are being sworn to by you freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, in this cause number, Mr. Rhodes, there's an indictment in here charging you with the offense of possession with intent to promote child pornography. That offense is alleged in the first paragraph of the indictment, which is up on the screen. Second paragraph of the indictment alleges a prior felony conviction for the offense of aggravated sexual assault of a child. Next paragraph alleges another felony conviction for failure to register as a sex offender. Get down to the plea documents I need to go over with you on this one. The first one's going to go, do you understand all the allegations and the charge in the indictment?
Yes, sir.
All right, I'm going to need to read these enhancement paragraphs to you, and I'm going to need to take your pleas to the enhancement paragraphs. You start off with the offense of, and these will be reflected over in the plea documents under the acknowledgement of admonishments. You start off with an offense charged in the first paragraph of possession with intent to promote child pornography, third-degree felony, and then you move to the second paragraph. It alleges you have a prior conviction for the offense of aggravated sexual assault of a child. I'm going to read that one to you. If you enter a plea of guilty to that one, it will enhance your sentencing range from a first degree, from a third degree up to a second degree, which would carry a sentencing range of not less than 2 years or more than 20 years in the Texas Department of Corrections Institutional Division, fine of up to $10,000. Do you understand that, Mr. Rhodes?
Yes, sir.
Then when I come down, I'm going to read the third paragraph to you, which alleges another prior felony conviction for failure to register as a sex offender. If you enter a plea of true to that one, as alleged in the third paragraph of the indictment, that's going to enhance your sentencing range up to not less than 25 years, no more than 99 years in the Texas Department of Corrections Institutional Division or life, with a fine of up to $10,000. Do you understand that?
Yes, sir.
All right, I'm going to read the second paragraph to you out of this indictment. It's up on the screen. And it's further presented that prior to the commission of the charged offense, hereinafter style the primary offense, that on the 26th day of October 2000, in cause number A10065 in the 173rd District Court of Henderson County, Texas, it's alleged you were finally convicted of the felony offense of aggravated sexual assault of a child. Are those allegations true or not true?
True.
And the next paragraph reads, it is further presented that prior to the commission of the primary offense and after the conviction in cause number A10065 was final, it's alleged you committed the felony offense of failure to register as a sex offender, and you were finally convicted on the 11th day of September 2013 in cause number 0070776-13 in the 7th Judicial District Court of Smith County, Texas. Is your plea to those allegations true or not true?
True.
Are you entering your plea of true to these allegations freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, as before, the court finds these allegations to be true based on your plea of true. Do you understand now your sentencing range for the offense of possession with intent to promote child pornography as alleged in the first paragraph is now first-degree felony as alleged, carrying a sentencing range of not less than 25 years, no more than 99 years or life in the Texas Department of Corrections Institutional Division. Fine may be assessed of up to $10,000. Do you understand that?
Yes, sir.
All right, these plea documents again, signed by you and Mr. Davidson. Now, if you plead guilty to the indictment now alleged as a first-degree felony, the state's going to recommend your sentence at 50 years in the Texas Department of Corrections Institutional Division. As part of your plea agreement, that would be ordered to run concurrent with the sentence assessed in cause number 24105-8520. Is that your plea agreement, Mr. Rhodes?
Yes, sir.
Is that it, Mr. Davidson?
Yes, Your Honor.
Is that your recommendation, Mr. Chairman?
It is, Your Honor.
These are the other plea documents I've got all signed, sworn to by you, signed by your attorney, Mr. Rhodes. In addition to your plea agreement, I've got an acknowledgement of admonishments. Gives you 5 admonishments. You've got another waiver of trial by jury, waiving and giving up your right to trial by jury. You signed and sworn to a stipulation of evidence, State's Exhibit 2. That'll be the next one we're coming to is a waiver of confrontation and agreement to stipulate testimony, signed and sworn to by you. Then we're going to go over the stipulation of evidence, States 2, signed and sworn to by you. Do you understand the stipulation of evidence in this cause number, as in the other one, signed and now sworn to by you, as a written judicial confession by you to all the allegations and the charge in the indictment?
Yes, sir.
And we've got an agreement to stipulate testimony in the case. We've got a form for a waiver of appeal, waiver of motion for new trial, request to allow a waiver of the pre-sentence, which is approved, and also the trial court certification of your rights to appeal. Now, all these plea documents signed and sworn to by you. You did go over all these plea documents with Mr. Davidson, your attorney, is that correct?
Yes, sir.
And you understood the meaning of all these plea documents when you signed and swore to them, is that correct?
Yes, sir.
All right, do you still wish to go forward on your plea of guilty to the indictment charging possession with intent to promote child pornography, which has now been enhanced up to a first-degree felony?
Yes, sir.
All right, do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment, which we've already talked about, other than what you've already told me?
No, sir.
All right, the court takes judicial notice of Dr. Proctor's report, thoroughly reviewed by the court in the companion case. Do you understand everything you're doing in court today?
Yes, sir.
Have you been over everything you're doing in court today, as well as the facts of your case with Mr. Davidson, your attorney?
Yes, sir.
Is he competent, Mr. Davidson?
Yes, Your Honor.
Any evidence of incompetence, Mr. Chambliss?
No, Your Honor.
Court notes State's counsel signed his consent approval of the waiver of trial by jury. All the other waivers signed by the defendant, signed by his attorney. All right, you understand the allegations, the charge in the indictment, the full range of sentencing, and all of your plea documents. Is that correct, Mr. Rhodes?
Yes, sir.
Do you have any questions for me about anything?
No, sir.
All right, in cause number 2410824-19, what is your plea today to the indictment charging you with possession with intent to promote child pornography enhanced to a first-degree felony?
Guilty.
Are you Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Has anyone threatened you in any way or promised you anything or coerced you, made you plead guilty?
No, sir.
Are you entering your plea of guilty to the indictment today freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment?
Yes, sir.
Are you entering your plea of guilty to the indictment today as a result of any type of delusion you have in your mind or some type of unrealistic hope of pardon, parole, or leniency?
No, sir.
All right, the court does receive and accept your plea of guilty. What do you have, Mr. Chance?
Your Honor, we would offer states 1, the plea package, states 2, the sign and sworn to stipulation of evidence, and states 3, the discovery compliance.
Without objection, Mr. Davidson. Any objection, Mr. Davidson?
No, Your Honor.
Court admits into evidence without objection, states 1, 2, and 3. Court having admitted into evidence, states exhibits 1, 2, and 3. The court does find the defendant's plea of guilty was entered to the indictment in this cause number freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty. The court, based upon the evidence admitted into the record on the defendant's plea of guilty, the court does find the defendant guilty of the offense of possession with intent to promote child pornography and enhance first-degree felony as alleged in the indictment. Moving to sentencing.
State would offer states 4, which is a digital copy of the state's written discovery.
No objection.
States 4 is approved, admitted into evidence by the court. The court in this case then, based upon the defendant's plea of guilty to the offense of possession with intent to promote child pornography enhanced to a first-degree felony, the evidence presented and admitted into the record by the court does find the defendant guilty of the offense of possession with intent to promote child pornography enhanced to a first-degree felony as alleged in the indictment. The court finds the defendant guilty of the offense alleged against him by the state in its indictment. The court follows the plea agreement with the recommendation of the state, sets the sentence at 50 years in the Texas Department of Corrections Institutional Division. No fines, assessed, court costs are ordered to pay, restitutions ordered to be paid if determined to be due, credit for time served granted on the sentence. Any legal reason to bar formal sentencing, Mr. Davis?
No, Your Honor.
Finding the court does formally pronounce the sentence, the court does find the defendant guilty of the offense of possession with intent to promote child pornography and a first-degree felony. Follows the plea agreement and the recommendation of the state and assesses the sentence at 50 years in the Texas Department of Corrections Institutional Division with credit for time served. No fines assessed, court costs are ordered paid, restitutions ordered to be paid as determined due by post-sentence. Sentence is formally pronounced at 50 years in the Texas Department of Corrections Institutional Division. As in this case, along with the other one, Mr. Rhodes, you have filed with the court, signed by you and Mr. Davidson, a waiver giving up your right to appeal and a waiver giving up your right to file a motion for new trial. Do you understand those waivers?
Yes, sir.
Are you waiving your right to appeal freely, intelligently, knowingly, and voluntarily?
Yes, sir.
Are you waiving your right to file a motion for new trial freely, intelligently, knowingly, and voluntarily?
Yes, sir.
Court does receive and accept the waivers, orders, and file the papers of the cause. Mr. Don Davis has been your court-appointed attorney. Are you satisfied with Mr. Don Davis's legal representation?
Yes, sir.
It'll be the judgment of the court then to be signed tomorrow that in this case, the court having received and accepted your plea of guilty, admitted the evidence in the record, the court having found you guilty of the offense of possession with intent to promote child pornography enhanced to a first-degree felony as alleged in the indictment. The court follows the plea agreement and the recommendation of the state, assesses the sentence at 50 years in the Texas Department of Criminal Justice. The 50-year sentence is ordered to run concurrent with the sentence assessed by the court in 2410585-20. Each sentence assessed and each cause number is ordered to run concurrent or at the same time. Both sentences assessed with credit for time served. Again, then this one, Mr. Rhodes, I have waivers of your right to appeal, waivers of your right to file a motion for neutrality. He's presenting those to the court now. And are you waiving your right to appeal?
Yes, sir.
And are you waiving your right to file a motion for new trial?
Yes, sir.
Court receives those waivers and motions, order them to file the papers of the cause. You've already told me you're satisfied with Mr. Don Davidson as your court-appointed attorney. It'll be the order of the court now, Mr. Rhodes. You will be continued to the custody of the sheriff until you can be transported to the Texas Department of Corrections to serve a life sentence assessed by the court in the preceding case and to serve the 50-year sentence assessed by the court in this case. Both sentences are assessed with credit for time served and ordered to run concurrent or at the same time. Waivers of appeal in both cases are accepted. Anything else, Mr. Chambliss, on either case?
Your Honor, just for record purposes, there was additional discovery in the child pornography case that obviously was not produced to Mr. Davidson due to the nature of the discovery, but it was made available for inspection. And so for purposes of making sure the record is clean, I just wanted on the record that all discovery involving both cases was either provided to or at a minimum made available to the defense attorney.
Correct, Mr. Davidson?
That's correct. My understanding is that Mr. Chambliss and Mr. Rhodes and myself signed off on a disposition of evidence regarding those materials.
All right, the defendant, Mr. Rhodes, is continued in the custody of the sheriff until such time as he can be transported to the Texas Department of Corrections Institutional Division to serve the life sentence assessed by the court for the offense charged in the indictment in that cause number, and until he can serve the 50-year sentence assessed by the court in this cause number 2410824-19. Both sentences assessed by the court in each cause number are ordered to run concurrent at the same time with credit for time served, waivers of appeal, waivers of motion to file a new trial, accepted and approved by the court in both cause numbers. There's nothing further, the court will order the defendant to continue the custody of the sheriff until he can be transported to the Texas Department of Corrections Institutional Division and serve the sentences assessed by the court to run concurrent with credit for time served. Anything else now, Mr. Chambliss?
No, Your Honor.
Is there anything else now, Mr. Davidson? All right,
No,
we'll
Your Honor.
recess.